This is Scott Becker with the Becker Private Equity and Business Podcast. I'm joined today with one of the most brilliant people I get to visit with regularly. We're joined today by David Pivnick. David's a partner at McGuireWoods. He works on typically white-collar and criminal litigation. He defends and works with often private equity. Got an extremely active practice, valedictorian from his law school class. He's overall a brilliant person. He joins us regularly to talk about trends that he's watching, what he's thinking about, and so forth. David, let me tee it up and ask you, what are some of the core issues that you're watching currently? What's on your agenda? What are you watching?
Yeah, absolutely, Scott. Appreciate you having me on, and always happy to chat. You know, I think I frequently, when asked this kind of question, I often talk a little bit about, you know, looking at DOJ enforcement trends, where the DOJ is spending its time directing its enforcement efforts, and also, frankly, where we're seeing cases being brought under the False Claims Act by whistleblowers, and what types of theories are being alleged, because I think, you know, that those wins are typically what will impact, you know, our clients and sort of direct where I'm going to be seeing issues in the future. So that's something I actively monitor, you know, all the time, and now is no different. The other thing, though, that's somewhat more timely, which I am monitoring, you know, less closely, I think, than some of my colleagues, but am actively monitoring, is the FTC rulemaking around non-competes, because I think that's going to have, assuming the final rule is adopted and there are meaningful changes, you know, it's going to have a significant impact on businesses going forward in terms of what can be done with non-competes, and with that in mind, how to handle employee issues to try and keep people within the company and avoid turnover, and people who had fewer options before potentially having more flexibility now with limits on non-competes.
Thank you very much. And what is there an expectation of this FTC rule? I mean, they've, I guess, passed it. It's supposed to come law in 4 months. There's a bunch of cases trying to challenge it. What is your sense of what's going to happen with that?
I think it'll be interesting. I mean, I think it's going to take effect. Whether or not there's traction in some of these cases, I'm not close enough to at this point to know whether those will succeed or not, but I certainly expect it's going to be litigated for a long time to come in terms of the enforceability here and what that means for non-competes. I also think it's going to create a lot of litigation around some of the nuances of the rule, in terms of it's not just employment, it's also whether or not you provide services, for example, is subject to the carve-out. Whereas, you know, we do a lot of work for private equity clients who are entering into multiple agreements at the time of a transaction, some of them including a non-compete and other restrictive covenants, you know, in the transaction documents themselves, which I think will remain enforceable, versus in an employment agreement that's signed as part of the transaction. So you might have a situation where, you know, two or three non-competes are signed in a given set of agreements with one transaction, and one or two of those might be nullified, but one or two may remain in place and enforceable, which can often have the same effect. So I think it's going to be interesting as things come into play, both the litigation challenging the rule itself, but also, frankly, even assuming the rule remains in place, I think there'll be a decent amount of litigation spinning out of some of the nuances of how the rule gets enforced practically.
Yes, and certainly when private equity funds or other buyers, I mean, there's multiple different kinds of non-competes. Obviously, in the law firm, really, you don't have non-competes. Professional services firms, some, it's all over the board. When people buy a company, though, always expect the sellers to sign non-competes. I know there's all kinds of restrictions on what you'll be able to do here, and some states already have restrictions. But is there discussion of that having a material impact on people buying businesses if they don't believe the sellers can sign valid non-competes, or they can't tie them up? Because the last thing somebody wants to do if they're putting millions and millions or $100 million into business is to have the executives or the leaders, the founders, go out and start the same business again in competition. Any sense of that, and whether this will be a tempering to the deal market, or how that look, or people start to try and find other ways around it? What are people talking about there?
I don't personally think right now it's going to temper the deal market. I mean, at the end of the day, I think funds have money to spend, and there's going to be buyers and sellers in the market who are looking to make a deal. I think the nuances of some of those deals could be interesting in terms of, again, I think that there are good arguments that non-competes that are based on the transaction that are tying the seller's hands as part of an exit, that there's going to be a broader path to continuing enforceability on that front. So one, there are ways to continue to protect through non-competes. I think that will be litigated in the future, but that I think continue to be a pathway. But the second thing is I think there's going to be other mechanics that are placed into transactions to try and protect entities on that front. That could be holding funds back, paying certain money as bonuses tied to remaining with the company and incentivizing people to stay. And it goes to what I said earlier. I think the reality is, as you said, law firms don't have non-competes as a general statement. So there's an onus on me and my colleagues at McGuireWoods to treat our people well and to motivate them to stay based on how they're treated, how they're compensated, et cetera. And I think there's going to be a higher priority from a business standpoint of putting things in place from a human resources standpoint, from a people standpoint, to keep people happy and staying and loyal. But that obviously can also get tied to financial incentives and metrics, delaying some of the payments and doing other things that will keep people honest, so to speak, because they have a financial risk if they don't adhere to the terms of the agreement.
Now, let's say a private equity fund, a platform, orthopedic platform is buying a 10-person orthopedic practice. They would typically expect they'd pay them some money up front. They'd have contracts with them going forward. But they would not want those orthopedic surgeons to leave in a hurry because they wouldn't buy the practice if that was the case. I guess this will be a challenging question to see how these kinds of things move forward, because people will have concerns about that. If you're buying a practice, a sort of add-on, bolt-on to a larger platform, and people can leave after they sell the practice, it's going to lead to lots of creativity in trying to tie people in, isn't it?
Yeah, I think that's exactly right. And I think it's going to require even more creativity and more thought around the physicians, where there are associate physicians, and that, you're buying a 10-person orthopedic practice and 4 of the physicians might be partners who are going to be selling equity, and other physicians are going to be sort of coming along as part of the transaction as associate physicians, and they're not going to be signing off on all the documents. And so you're going to have a bigger challenge with regard to those physicians, but it's also going to be, again, a process of figuring out how to keep those folks motivated, loyal to the company, and staying long-term. So I think it will put a premium on treating people right and making sure that they're able to see the bigger picture and the value in staying put versus simply moving, because there may be some level of increased mobility that comes out of the FTC rule, certainly part of what the FTC was intending.
No, absolutely fascinating. And again, all of these situations where, a front desk employee is required to sign a non-compete, and it just seems egregious and unfair. Then we see other places where it might seem more fair, and it's all over the board in terms of what seems appropriate and not appropriate. And certainly feels like when a fast food chain is required their fast food workers, the day-to-day workers that are working minimum wage jobs sign non-competes, it seems like a complete abuse. In other places, it seems quite rational, and it'll be fascinating to see how this all sorts out and whether ultimately this withstands court challenges. There's going to be plenty of court challenges to the FTC ban on non-competes. Fascinating.
Absolutely. It will be very interesting to see how it plays out, and I think it'll be an added piece of litigation, from a subject matter standpoint, that will help keep litigators busy into the future.
No, 100%. David Pivnick, I want to thank you again for joining the Becker Private Equity Business Podcast. Always great to visit with you. Thank you so much for joining us.
Happy to be on. Thanks for having me, Scott.